Right, and so we are on the record in the matter of the city of Michigan versus Laredo Montero Diaz, 24105.
Good morning, Your Honor. Todd Lanta, appearing on behalf of Laredo Montero Diaz.
Right, good morning, counsel. I do apologize for your delay today. And your name, ma'am, please?
Laredo Montero Diaz.
All right, so today's the date scheduled for sentencing on your client's plea to the purchase the pistol without a license. And counsel?
Yes, Your Honor. I have gone through the pre-sentence report with Ms. Montero Diaz. Just a very minor correction, Your Honor, on the first page, having to do with her employment, her general background. It'd be in the second paragraph, middle of the second paragraph. Although it says she's not employed at this time, it says she was suspended. She was actually terminated, Your Honor, and I just wanted to point that out for Your Honor.
Okay, was that as a result of this matter?
Yes.
Okay. And professional mixologist. What?
I'm a bartender, Your Honor.
Okay. All right. And so what are you doing for employment now?
I have been desperately seeking employment for the last 2.5 months. I cannot find a sustainable employment to compensate what I've lost. I've been turned down several jobs because of this on my record. Right now, I'm in a very bad state because of this. I'm losing my house. I'm getting ready to have to come see you for an eviction court. My credit has taken a hit. I haven't been able to pay my bills. And like I said, I have not been able to find adequate employment. And I am not allowed to go back to the airport because this is technically still on my record.
It's a TSA. Even though she's a Kennedy Bar, Your Honor, at the airport, they still have the TSA clearance. And Your Honor, we had adjourned this matter a number of times, trying to structure a plea where this would not be the result, and even with an under advisement, unfortunately, she's in this position. And Your Honor, I wanted to share that with the court judge in hopes that you would take that in consideration regarding fines and costs. And as you see, Your Honor, she's a single mother of 3. And I do believe she is truly trying to find employment. We talk about it every time she and I have a phone conversation or meet.
Okay, and so ma'am, I understand that you received this firearm from your grandfather, or it was your grandfather's. You didn't think you had to register it. Or even if you're unsure, you should always contact somebody that potentially would know, such as law enforcement, police station, or something, to know what to do with it, especially because you keep it in your vehicle, right? Because you have some concerns regarding your son.
Yes.
So
I started doing that when Jaden started flying off the deep end. So that was the only thing that I could do that I know personally at night that he would be safe.
okay, and so how is that situation going?
Well, Jaden has continued with treatment. He's still seeing psychiatry. He's medicated. He's been doing the classes that you ordered on him. He did test negative. We had an IEP meeting on Friday. They're going to give him, they don't want to put him back in the physical school because he's too far behind on credits, but they're going to put him in a work program that is complementary to him being in school. So they're working with him and he's doing okay. It's just all of this right now is kind of hard for us.
Okay, here's what I'm going to do. I do find that after hearing from counsel, hearing from Ms. Montero Diaz, or counsel, is there anything else you want to say?
Thank you.
And reviewing the report, the recommendation, knowing the history with Ms. Montero Diaz as well as her son, just because there's been numerous court contacts, I'm not saying it's a negative, understanding counsel and Ms. Montero Diaz. It's just the reality that I understand it. The court's going to find that there's reasonable grounds to harm MCL 769.5. The court's going to order 6 months probation. You're eligible for early discharge. The court's also going to take this matter to 771.1 status. The court's going to order not to violate any criminal law or unit of government. You have to leave the state without the consent of the court. You are to report to your probation officer truthfully as often as your probation officer may require, in person, writing, or virtually. You have notified your probation officer immediately of any change in address or employment status. You don't use any alcohol or drugs unless prescribed and be subjected to random testing. The rehabilitative goal for that condition is to monitor your progress to maintain absence and sobriety, as well as to make sure there isn't anything else possible for even your son to access. The court's going to order no weapons or firearms. The rehabilitative goal for that condition is to ensure safety of the community and reduce recidivism. And the court's going to order a gun safety class. The rehabilitative goal for that condition is just so, man, that you're aware of all the laws that do go along with owning a firearm. I'm not sure if you're going to petition to receive that firearm back, or if that was permanently forfeited as a result of the plea. I didn't see that on there, and so I don't know. So just in the event you're going to petition for that back, you'll just need to have that that knowledge. Okay? Any questions on the terms and conditions?
No, Your Honor. Thank you.
All right. The court's going to order the following fines and costs. The court's going to order a $100 fine. And actually, let me just clarify. Per the statute is a $100 fine, mandatory forfeiture of the weapon. So you can't petition for it to be returned. All right. Screening assessment fee, $100. $300 for the supervision oversight fee. That's 6 months at $5, $50 a month. Since you're eligible for early discharge, up to $150 of that may not be due. $200 for the cost of prosecution, crime victim assessment fee $75, justice system assessment fee of $50. So $825. As far as low as I can go, counsel.
Thank you.
Knowing that 150 of that may not be due, so it could be reduced even further. So what I'm going to do, ma'am, is I know that you're not working right now, so I'm going to order that for you to set up a payment plan through probation, okay? I'm going to order by June 30th. I would presume by then you would have some income set up, okay? Since you are eligible for early discharge, I did order you're eligible for early discharge as long as all the following have occurred. You completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violation. All money is going to get paid in full, or you've made a good faith effort for making full payment. Okay?
Thank you, Your Honor.
Good luck to you, ma'am. Please have a seat over in probation. Okay?
Good to see you, Your Honor.
All right, you as well.
Thank you.
All right, let's go off the record for a moment.
Okay. Go! Hand me my screen box. Now go freak. Rah.
Okay, and so let's go on the record in the matter of the city of Wyandotte versus Candace Hardesty, 24239. And appearance, counsel?
Your Honor, for the record, John Goldclaw, P. 30758, on behalf of Ms. Hardesty, I want to point out to the court that this matter has been individually appointed. I've been individually appointed to handle this matter today because the court was concerned that she had been incarcerated and wanted to get this sentencing and bond violation up before the next available date that I had. I just want to put that on the record in my discussions with Ms. Shaw.
And so the court will note that that seems to, that yes, counsel, you were the attorney originally assigned in Ms. Hardesty's matter. This matter was scheduled for sentencing on April 24th after a plea that had been entered on the record. She failed to appear for sentencing and a bond violation on that date. A warrant was then issued on April 29th. And then Ms. Shaw received notification from the Wayne County Jail that Ms. Hardesty was in custody. And so the court set this matter for today's date for the bond violation hearing as well as her sentencing date. And the court, your correct, counsel, you were then contacted because you were the original attorney, and then the court gave you permission to zoom in as you were in another court today. The court can proceed, counsel, if you're ready to proceed.
We are ready to proceed, Your Honor. I have spoken to Ms. Hardesty. I did, and I've had an opportunity to review the pre-sentence report and the bond violations with her.
Okay, and so as the bond violation, counsel, are we proceeding with the hearing, or is that being resolved?
That's been resolved, Your Honor. I've discussed this with her. We reviewed that. She admits that she did fail to appear on a number of occasions, and because she didn't have the money to pay. I explained to her that that's not how it should be handled, and she is guilty of that bond violation. Also, Your Honor, she indicated to me that she is on certain prescription drugs and that, but not cocaine. And so the bond violation was also part of testing positive. Is that correct, Ms. Hardesty?
It is. I recently just started a job though, about a week ago.
Ms. Hardesty, we're talking about the bond violation first.
Right, I know. Part of the
Okay.
bond violation is me not paying for a few of the drug testing.
No, hold on, excuse me, just a moment. The bond violation, let's see, I'm going to just be very clear on that. The bond violation on April, you were supposed to, on March 20th, you were ordered to submit to random tests and to test that day. You did not register and begin testing until March 25th. And then the results are on March 25th, you tested positive for cocaine, Valium, marijuana. March 27th, you failed to appear for testing. Also, March 20th, you failed to register and test. April 5th, you tested positive for Xanax, cocaine, Valium. April 9th, positive for cocaine. April 13th, April 16th, you failed to appear. So that is the bond violation. Those are the bond violations for the bond violation. Here on the schedule. Excuse me.
For Xanax, but
Excuse me. Ms. Hardesty.
yes.
It's difficult enough on Zoom that when one's speaking, another one cannot because it pulls from the volume. Also, my court recorder cannot get what we're both saying if we're both talking at the same time. So I wasn't quite finished yet. So what I was saying is that those are the bond violations that were alleged, and those are the bond violations that were scheduled for the April 24th bond violation hearing.
Now,
Okay.
can I tell you,
So
I didn't register on the 20th. I did go there. You can ask them. I was there, but I thought it was only $25 and it was $55 and I didn't have enough money. That's why I didn't register until the 25th. And it was a Thursday and I apologize.
Okay, so we'll get to all that in just a few moments. Right now, I just need to establish the basis for the plea.
Okay.
Okay.
Yes, ma'am.
So, Mr. Goldpaw, your client's pleading guilty to the bond violations.
That is correct, Your Honor.
Ma'am, please raise your right hand. Do you sound your other right hand, please? Many people do that. Okay. Do you solemnly swear from the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. And you heard the allegations regarding the bond violation hearing, correct?
Yes, ma'am.
As to those violations, ma'am, how do you plead? Guilty or not guilty?
I plead guilty. I misunderstood for day too. I'm sorry. It won't happen again.
And you understand that you have the right to have a contested hearing in this matter. By entering into a plea, there will not be that contested hearing.
I understand.
I'm sorry?
I was wrong. I understand.
You understand the possible penalty as a result of your plea?
I do, ma'am. I do. I'm hoping that you'll take it easy on me for the simple fact that I've just started a new job and I'm going back to school currently full time.
Okay. Okay, and knowing all that, you want to continue with your plea?
I do. I want to take responsibility for my actions.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am. Nope.
All right, counsel, if you can please audio your client regarding that.
Thank you. I'm sorry. Ms. Hardesty, on the dates in question, were you ordered to go for testing?
I was.
And were you directed as terms and conditions of your bond that you were to go for drug testing? Is that correct?
I agree, yes.
And on the dates mentioned, stated, and also you were ordered to test negative. And is it true that on March 20th of 2024, you failed to register? That on March 25th, you tested positive for cocaine, Valium, and marijuana. And on 3/27/24, you failed to appear. That on 4/5/24, you tested positive for Xanax, cocaine, and Valium. And on 4/9, you tested positive for cocaine. And also that you failed to appear on 4/13 and 4/16 of 24.
Yes, sir. I did. I apologize. It won't happen again.
And you understand this was in violation of your terms and conditions of your bond. Is that correct?
Yes, sir.
Defense satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, factually accurate. And the court will accept your plea to the bond violations. Counsel, let's handle the sentencing on the bond violation as well as your client's plea simultaneously.
Thank you, Your Honor.
And so then, counsel, as to the sentencing report and recommendation.
Your Honor, we did have an opportunity to review that.
There's possibly updates because your client's stating that she is now employed.
That is correct, Your Honor. And these were the additions we were going to make to the the recommendation, well, to the PSI. What's stated in the PSI, there is no additions, deletions, or corrections to be made. However, Your Honor, she indicated to me that she is now working with family members in a cleaning business, and that they clean jail cells and throughout the state. Also, she is presently enrolled at Phoenix, University of Phoenix. At this point in time, successfully, she received some income help in that matter, scholarship of some sorts, and she is maintaining her academic pursuits. Other than that, Your Honor, as I've indicated, I've advised her that she should try to get a more substantial and more permanent employment. However, as I've indicated, she's also going to school at this particular time. What are you taking at University of Phoenix?
Going for psychology, but I'm doing my bachelor's.
Okay, ma'am, I cannot, Ms. Hardesty, I
Yes.
can't hear you.
Speak up.
I'm going for psychology, and I've already got 60 credits. So I'm already halfway there to my bachelor's.
Hold on, when were you first enrolled?
Back in 2010 or 2008, and then I quit for a while, and I just re-enrolled about 3 months ago. Not even 2 months ago.
So
I'm
then
sorry.
why did you, I'm sorry?
It was only 2 months ago. I apologize.
So did you disclose that to probation in your PSI?
No, not yet. It was the day after I was there that I started. So I want to say it was the end of March that I started school. I can prove everything. I can give you paperwork. But if I'm absent any more time, I'm going to lose my grants. And I don't want to do that. Please, I'm begging you.
Well, ma'am, why didn't you show up for court on April 24th?
I thought my court date was May 14th, and I apologize, and it won't happen again. I promise you, ma'am. I promise. It will not happen again.
Hold on, ma'am. You were here in court
Correct.
on March 20th, where this court stated April 24th. I don't even have May 14th written down anywhere, so I'm not sure
I don't know why I wrote
where
that
that
date.
date even came from.
I don't know, and I apologize. It won't happen again. I promise you, it will not happen again. I promise you, it will not happen again. Everything else, I did what I was supposed to do. I did my testing. I called every day. I don't know why they said I missed 2 days in 1 week, because I called every day. I kept my tether on, checked in with my tether officer every Monday. I never heard from
You didn't, ma'am. You didn't do everything you were supposed to do. Because you were ordered to not use any alcohol or drugs that are not prescribed. And you tested positive for cocaine 3 times. Do you have a prescription for Valium?
Valium. I don't know how I tested positive for Valium or Xanax.
Ma'am, do you have a prescription for Valium?
I do.
Do you have a prescription for Xanax?
I don't.
Do you have a prescription for marijuana?
I don't.
Okay, so you didn't do everything you were supposed to do because you were supposed to not use any of those substances, ma'am.
I get outpatient treatment as soon as I get
Okay. Okay.
out.
Well, no, I take, give me one. Let's give me one. I'll take one.
Mr. Gopal,
But I promise I will not miss another court date, and I will do everything I'm supposed to do. I just don't want to lose my scholarships and my grants.
ma'am, you,
Yes,
you're saying that you work for your family cleaning company. What is
I do.
that?
Clean businesses, like grocery stores at
I
9.
have a hard time hearing you when you first start talking.
It's we clean businesses like grocery stores at nighttime, jail cells. We go all the way to Toledo, Ohio. Her name is Kendra.
What's the name of the What is the name of the company?
I'm not even sure what her company's name is. I just work under the table for her. I can get you all that information today if you'd like.
Why do you work under the table? Why don't you get a paycheck?
That's just how she does it, I guess. I don't know. I don't really know. I can get employment elsewhere though, if you'd like. That's not a problem. But I will get all her
That's
information.
your cousin?
It is my cousin's. It's my cousin's friend. Yeah, my cousin works for
Your
her.
cousin's friend?
No.
Ma'am, bless you. Your cousin or your cousin's friend?
My cousin's friend, and he brought me on with them.
And they don't do a background check?
Mm-mm.
Is that no?
No, ma'am.
Here's, counsel, the court has some serious concerns regarding some of the credibility of your client here. I don't even know where the May 14th date came from, that she said that, she thought she had a court date. She has a warrant out for her arrest in a different jurisdiction. That would be in Lincoln Park.
Mr. Clifton, him and I already talked about that. I just have to go in and see Mr. Clifton, and he's gonna help me take care of everything.
I'm sorry, I didn't understand anything you just said.
Judge Clifton, I've talked to him already. He said I just need to come into his courtroom, and he'll help me take care of everything. So I will do that this week, I promise. I will get that taken care of by the next time I see you. Everything will be A-okay, I promise. I will not have pissed dirty no more. I will have all my warrants taken care of. Everything will be on the up and up. I guarantee. I give you my word. And if I screw up my word, then you can
Okay,
back me up.
ma'am, please also remember, that you're still in court.
Yes, ma'am.
So just make sure you're choosing the correct words.
And I know it's a day late, but happy Mother's Day as well. Kind of sucked that I was in here for Mother's Day.
Well, ma'am, that's where you need to be a bit more on top of things as far as with your court dates and,
Right.
and in with life in general. So here's what the court's going to do. As to the bond violation,
I even missed my daughter's prom.
ma'am, I can't understand, I can't hear what you're saying.
I even missed my daughter's prom this weekend, so I definitely have had a shitty experience. I'm sorry, and I will not let any of this crap happen again. I promise.
Okay, ma'am, did you just say the word shitty?
No, I didn't. I said crappy. Sorry, I apologize.
Hold on, you're saying you said what word?
I didn't mean to. I meant crappy. I really had a crappy time this time.
Okay, so can you, okay, listen. You need to pay attention to details, ma'am. Because I just asked you if you said the word shitty and you said no, you said crappy, and then you rechanged it and said, well, I meant to say something different. So listen to the question that's being asked, because you're trying to tell me what you think I want to hear. First you said it was your cousin's place that you work, now it's your cousin's friend's place that you work. You're paid under the table, that's just how they do it. That doesn't seem to make business sense. So here's what the court's going to do. The court's going to, on the bond violation, the court's going to order, there are 7 violations, the court's going to order 7 days jail. Credit for, you've been in custody since Friday, so credit for 4 days.
Thursday.
Sorry?
Got here Thursday. They picked me up Thursday because Friday was prom. And I have 7 days also from the last time I seen you. So technically that's 13 days that I have spent.
What do you mean from the last time you saw me?
When I seen you last time, well, not this last time, the very first time I seen you, I had to spend 7 days in here because of waiting for the tether. I was already bonded out. So I had 7 days that week. And I was already bonded out 3 days prior. And then this time it's been 5 days.
Okay, well, right now I'm sentencing you on the bond violation.
Okay.
And so on the bond violation, you've been in custody since Thursday, so I'm going to order 7 days jail because there's 7 violations. In case you're wondering how I came up with 7 days, credit for 5.
Stay here 2 more days.
I'm sorry?
Do I stay here 2 more days?
Yes. As to the sentencing on the possession of drug paraphernalia, after hearing from counsel, hearing from Ms. Hardesty, reviewing the report, the recommendation, the police report, the criminal history, the court does find there's reasonable grounds to depart from MCL 769.5. The court's going to order the following. 18 months probation. You are eligible for early discharge, and the court will go over that in just a few moments. You're not to violate any criminal law of any of the government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. You're notified your probation officer immediately when you change your address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitated goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so you have assistance in providing coping mechanisms to maintain sobriety and prevent relapse. You're also to participate in fan meetings once per month. The rehabilitative goal for that condition is to get additional support services as well as additional recovery resources. You are to perform 80 hours of community service. The rehabilitative goal for that condition is to help you further develop work and life skills and get back to the community. The court's going to also order you to seek and maintain full-time employment. You want to work for the cleaning company in the interim, ma'am, that's totally fine. But you need to seek and maintain full-time employment. And you have to also provide proof of completing 20 job applications per week. The rehabilitative purpose for both of those conditions is so that you can gain further resources to provide financial stability. Any questions regarding the terms and conditions?
My only question is, can I please get out of jail today? Just for the simple fact that if I wait 2 more days, I'm going to lose my scholarships. I won't be able to do my attendance in class. That's the only thing I ask, please.
Sorry, I didn't understand what the first part of what you asked for.
If I stay here 2 more days, I'm going to lose my grants and scholarships in class. I haven't been able to do attendance at all in 5 days. Please, I'm begging you. I'm begging you, please. Can I get out today, please? I will do anything. I will show up in your courtroom today. I'll do anything you need me to do, please.
Ma'am, your credibility is a little bit low with this court.
No.
You have failed to appear for court. You failed to appear for drug testing. You have not complied with this court's orders to not use any alcohol or drugs unless prescribed. And
Let me prove myself.
no, ma'am,
Yes.
those are the consequences for your choices. So, but knowing the Wayne County Jail, I'm guessing that you get credit for some of your time in custody. So it's very likely that they may be releasing you today, but I don't have control over that. I don't set the Wayne County Jail policies. So the court's going to order a $300 fine, $100 screening assessment fee, $900 supervision oversight fee. That's $50 a month at 18 months. Since you're eligible for early discharge, $450 of that may not be due. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, warrant fee $50. Total $1,775. I'm going to order that you are to set up.
Can I go ahead and pay a lot of that?
Plan. Excuse me, I'm sorry, what's that, ma'am?
Could I go ahead and pay some of that early? Does it have to be every month?
I'm sorry, what?
Could I go ahead and pay some of that early? Or does it have to be every month?
There's not a prepayment penalty, ma'am, so you can pay something earlier if you have the funds to do so. But I'm going to order that you're to set up your payment plan for probation not later than June 30th.
Yes, ma'am.
You should have income established by then. As I did indicate, you're eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All monies have been either paid in full or you've made a good faith effort toward making full payment. All right, and what I'm going to also state, ma'am, is that you said that you were in custody for 7 days waiting for your tether.
Yes, ma'am.
And the court also wrote 7 days jail credit for 7 days. All right, and then, ma'am, what I'm also going to order is that you are to report to probation within 24 hours of release.
Okay.
So that you can meet and get your instructions. All right, thank you. Have a good day. All right, good luck to you. All right, so there's a reason that this court ordered alcohol tether on your client. There's also a reason this court ordered your client to participate in random testing. And also a reason why this court ordered your client to test while he was in Los Angeles at least one time. Did he do that?
We did not.
Of course not. He has zero regard for court orders. He's on bond in Los Angeles. Mr. Mihalov claims he was confused. I'm not sure what he was confused of. This court was very clear. This court allowed you to leave on a personal bond, sir, and get the tether on your own. You've shown you cannot do that. This court also allowed you to test randomly. You didn't do that either.
No, Your Honor,
I was in the... This court, sir, this court did not have to permit you to travel to Los Angeles for your court date. It allowed you to do so because you were supposed to have the alcohol tether on. You were supposed to have tested while you were in Los Angeles. You did none of that. You have complied with zero bond conditions. Zero. And now your attorneys are arguing to allow you to be released again because you're going to comply with the conditions. This court has zero confidence you're going to do that. In the matter of the City of Riverview versus Brent Mihalov, 24195. And appearance counsel.
Good morning, Ellen Michaels, P67943, on behalf of Brent Mihalov, who is present over Zoom. Thank you for allowing us to appear over Zoom today. We consent to appearing over Zoom.
And good morning, Your Honor. Jamil Kuja, P71963, also appearing as co-counsel on behalf of Brent Mihalov.
Okay, thank you. And Mr. Kuja, I do see that your vehicle appears though it's not moving. Are you parked?
Nope. Parked.
Okay. All right. And so, Mr. Mihalov, your name for the record, please. I'm sorry. I'm having a problem with the Wayne County Jail volume or something. I'm not really sure. Can you state your name again, please, sir?
Brent Mihalov.
The first part. Oh, there we go. Okay.
Sorry, Your Honor.
All right. And so, counsel, you've indicated that today's the date scheduled for the pre-trial and that you have a resolution.
That is correct.
All right, would you like to please place that resolution on the record?
Yes, thank you so much. Mr. Mihalov will be pleading guilty to the charge of operating while visually impaired, and the charge of operating while intoxicated will be dismissed.
Okay, Mr. Mihalov, please raise your right hand. Do you solemnly swear or affirm the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth? I'm sorry?
Yes, Your Honor.
All right. And sir, you heard the plea that your attorney placed on the record, correct?
Yes, Your Honor.
I'm sorry?
Yes, Your Honor.
Okay, you may lower your hand, and just so you know, sir, it comes through more clear, all of the words when you're leaning in, okay? All right, as you amend the charge of operating while visibly impaired by alcohol, how do you plead?
Guilty.
All right, and counsel, if you can please review your client.
Yes, Your Honor. Yeah. Mr. Mihalov, I'm going to direct your attention to February 7th of 2024 at approximately 3 a.m. At that time, were you driving a motor vehicle?
Yes.
I believe so.
Is that a yes or a no?
Yes. Sorry.
And when you were driving that motor vehicle, were you driving it on a public highway or a public roadway?
Yes.
And while you were driving that motor vehicle on a public roadway, were you under the influence of alcohol?
Yes.
And did being under the influence impair your ability to drive safely?
Yes.
I'm satisfied, Your Honor.
Okay, and in what way did it impair your ability to operate a motor vehicle, sir?
I wasn't able to handle the vehicle correctly under the circumstances, especially the vehicle that I was driving at the time.
All right, and so you hit an object, correct?
Yes, Your Honor, I understeered and went over a curb in the middle of two one-way roads.
Okay. All right, and counsel, is there a stipulation for plea purposes as to the alcohol content of 0.215?
Stipulated.
Yes.
All right, the court does find the plea as knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement, dismiss the original charge, and you're going to get a sentencing date from probation. We're redoing our procedures a little bit. So probation will schedule you for a PSI and a sentencing date. So you'll get that date from probation counsel.
Okay.
So what I'll do is, because I know Mr. Mahalov is in custody in the Wayne County Jail, the court will find out from Wayne County Jail if there's ability on the camera to do that today, or if probation will call in to do a phone PSI with Mr. Mahalov tomorrow morning.
Judge, is it possible to address his bond?
Okay, well, first I just want to make sure everybody understands that procedure.
Yes.
Okay. Well, I'm sorry, what's that, Ms. Michaels?
Yes, Judge. We would like an
I'm sorry, you're breaking up.
opportunity to address the bond.
Right, that's what Mr. Kuja just requested.
We are asking for the opportunity to address bond.
Right.
We are asking for the opportunity to address bond now that a plea has. Yes.
Ms. Michaels, I think your connection is bad.
It is bad.
Thank you so much. I had a bad connection briefly. I had to move.
Yes, which is one of the reasons why I prefer in person. So in any event, yes. So who wants to address the bond, Mr. Kuja or Ms. Michaels? Because this court revoked your client's bond based upon the bond violations, which there were several. And so who's addressing that?
I can do that, Your Honor.
I'll address it, Judge.
Oh, you want to do it? Go ahead.
Oh, go ahead, Jamil.
Okay.
Okay.
Your Honor, I know.
Thank you so much, Your Honor.
Judge.
Okay,
are you ready for me?
Hold on.
Sorry about that.
Hold on, just one moment. There has to be some coordination, please, between the council, because our record is kind of looking like a disaster right now. So who is going to address bond, Ms. Michaels or Mr. Kuja?
I will do
Mr.
it.
Kuja, okay. Please proceed.
Thank you. Your Honor, I understand the court revoked his bond previously because he failed to comply with your order that he be outfitted with an alcohol tether. He was traveling for another case. His time was mixed. He didn't take it as seriously as he should have. He understands that. He's not looking to make any excuses for violating the bond. What we're asking the court to do at this point is he's been in custody now for close to a month. He's about to lose his home. We're asking if the court would reinstate the bond. He's in the jail. The alcohol tether would be placed on his ankle before he's released from the jail, and he would comply with any and all conditions. He sees the seriousness of complying with the court's order. So we're asking if the court would release him on the alcohol tether to return for sentencing in person. And we would ask the court at that point if you would sentence him to a term of probation in the sobriety court.
Sobriety court, which sobriety court are you looking at?
You know, I was under the impression that you run a sobriety court in your district. Is that not true?
What we run is a mental health treatment court. And so we do address, with those participants, we do address individuals that have addiction issues as well, or sobriety issues as well. So that's where we're at with that. So I don't know if you're looking for sobriety court or mental health treatment court.
I guess, Judge, the mental health treatment court, if it would stay before Your Honor, would be something we'd explore with the probation department to see if he's a fit for that. But he does want to comply with the court's orders, get through a term of probation. He understands the seriousness of what he's done, and just wants an opportunity to be able to get past this without losing his home and his bill. He's behind on all of his bills, and everything's piling up on him now that he's in custody. And so we're asking the court if you would release him on bond, knowing that he will comply at this point. He's done about 30 days in jail almost.
Okay, so, let's see, April 24th.
Oh, it's about 20 days then. Not a month.
You count much quicker than I do, counsel, yes, 20 days, all right.
Judge, can I add one thing,
So-
please?
Okay,
Thank you so much. At the time Your Honor revoked his bond, you said that the jail should, or that he would be released for a alcohol treatment program. There's been no progress made to get him any sort of help or treatment while he's been there. He's really been cold turkey from his pain meds because of the burns over his body. So that these are all issues that he can address if released. Moreover, again, he had been in the hospital and has burns all over his body. Those wounds continue to fester, and if he's released, he can get the medical care that he needs for that. It doesn't serve him or the community for him to continue without getting help and treatment. Now that he's entered a plea, if he violates bond, his consequences are even more severe, because now he's probably guaranteed to be maxed out on the sentence of the plea. So he's in a position now where he has even more to lose if he violates bond. Thank you.
all right, thank you. The court will note that when the court did revoke Mr. Mahalov's bond, the court did order that defendant may be tethered to treatment through the Wayne County Jail if requested. Mr. Mahalov, did you request that treatment?
Sorry, I'm a little confused. What treatment should I have requested?
For your sobriety, your either mental health treatment or alcohol treatment?
Counsel, I don't really understand.
Didn't you
I'm
make,
sorry, you don't mind?
Your Honor, he made the request because he had us making calls to the jail to try to get him to see what's taking so long. I was told there was a long list of inmates waiting for drug treatment, and there just simply was not enough beds.
I was told I wasn't even on the list. According to them, they couldn't begin the process. You know, I'm not even waiting for that. I should be.
Okay.
Understand
The other condition I wrote on there was that file was to be marked medical, so that Mr. Mahalov could receive his medical treatment regarding his burns.
I do have physical injuries that I was in an outpatient program for at DMC, their burn unit. I am not receiving any medical treatment comparable, even remotely comparable to that here, even after these few weeks I've been here. Is that what you were asking?
You've been getting treatment while you've been there?
No,
For that?
not even remotely sufficient treatment.
No, so I
So
didn't
he's saying
ask
he's
if it was
getting-
remotely sufficient. I asked you, so you said something about the burn unit at Detroit.
Yes, Your Honor.
Okay, so while you've been in custody, have you been receiving some medical treatment for your burns?
The best I've gotten amounts to they've given me Band-Aids and some ointment, but really no. In truth, I haven't received adequate treatment of the nature that was necessary in the view of DMC's burn team. Nothing comparable to that, even close, no. Did I answer that correctly?
Well, I mean, you answered the question, so there's not a correct or incorrect answer for that one. You just answered the question, so thank you. And sir, who do you live with at the home in Brownstown?
I live alone, although following this, I'll probably stay with my friend across the street for a while, just until I get back on my feet, if that's permitted. Especially while I, take care of the things that I need to take care of, my obligations and so forth.
And where are you now? Where were you employed?
Essentially self-employed. I do freelance.
Freelance what?
IT work, such as software development and system administration, which is just, setting up computers essentially.
All right. Well, here's what the court's going to do. Well, please tell me the status of the matter in California.
I can address that. I spoke with his attorney in California. That case, it's a misdemeanor. It's in the trial stage. He has a
Sorry,
future
Ms. Michaels,
pretrial date.
Ms. Michaels, your connection is spotty. So, if you could please, start that over because I didn't get all the words.
I can fill it in if the court didn't hear it. Judge, he's in the pretrial process. There, we had spoken to his attorney out in California. It's basically in the pretrial process. He is going to have to return there for another pretrial, but I don't know that date.
Well, I don't know that this court's going to allow him to travel. If this court doesn't allow him to travel, then hopefully that court's going to allow him to appear remotely. Because this court allowed him to travel the last time, which is why he has now had his bond revoked because of those allegations, as well as the fact that he didn't get his tether on when he was supposed to.
I understand, Judge. If he's released, he's going to have to figure out a way to comply with both courts' orders. Whether that's if the court's not going to allow him to travel, his attorney in California is going to have to ask for him to be allowed to appear remotely, and see what happens then.
And Mr. Carmen, I'm not sure if you've been in there to hear the request by Mr. Mahalov's attorneys to amend bond. This court had previously revoked bond based on Mr. Mahalov's failure to report for the tether, and then there were additional allegations as well that had occurred.
Your Honor, no, I
and so,
apologize. I was in the bathroom.
okay, do you have any position regarding bond amendment?
Your Honor, I'll leave it in the court's discretion.
I'm going to amend the bond. This court's going to order GPS and alcohol tether, that you're not to be released without those. The court's going to order house arrest, except for your medical appointments.
Am I permitted to speak?
Yes, sir. Yes, Mr. Mahalov.
Your Honor, will I be permitted to do banking and such things of that nature, just productive activities?
He's just telling you to stay home.
Pardon me?
You can do it from home. Can you do it from home?
I have to appear physically in many instances, especially given the circumstances.
Judge, will the court give him like some hours, a couple hours a day to be able to tend to his affairs? Like maybe from noon to 5
hold
or
on,
something?
listen. No, listen. Mr. Mahalov, and counsel, I didn't mean to say that towards your purposes. Mr. Mahalov.
Yes, Your Honor.
I'm not clear as to why banking would have, that you're required to be in person for banking.
There are just a lot of things that I'm, given my current circumstances, for example, I don't have a phone, I don't have access to my old accounts and so forth, where I'll need to appear physically to show ID, be physically present and so on. It'll be a major hindrance if I'm not able to do that for, as Mr. Kuja said, maybe just a couple hours a day even would be sufficient. I'm not looking to do any traveling or to do anything beyond basics, but I may need time away from my home physically just to tend to my affairs. That's all I'm concerned with, really. Beyond that, nothing at all.
Okay, so.
And I will have someone with me. I'm sorry.
I'm not giving you a couple hours a day because you don't need, I can't imagine you have to do banking a couple hours every day. Because you'll just need to go to the bank one time, I would presume, to reestablish your accounts or whatnot with your identification, correct?
I do have to do a number of things following my being here that I think will take some time. I don't know. I don't mean to leave it open-ended, and I don't mean to be ambiguous or vague. I'm just thinking ahead. For example, I need to replace my electronics. I need to, maybe Mr. Kuja or Ms. Michaels, you could elaborate, but these are things that are going to take me time independently of just going to the bank. It's just miscellaneous things that I need to do to try to get back on my feet and to ensure that I'm in a position to even stay in my house under house arrest. Could you elaborate for me, Mr. Kuja? I see you're not muted. Do you understand what I'm getting at, or can you maybe phrase
I
this?
understand what you're saying. I mean, it's up to
Okay,
the
but
judge.
hold on, please. Hold on.
Okay.
Counsel, you both have asked for this court to amend the bond. Your
Right.
client is apologizing for being ambiguous, but he's being very ambiguous and very cryptic, and I'm not confident or comfortable that I'm going to be amending the bond with what he's putting forth.
My mistake.
Judge, really what he's saying, basically, he's lost his phone. He's going to have to go try to get a new phone. He's, I don't know what condition his house is even in. He hasn't been there, since he's been in custody. He's just asking if the court give him even just a little bit of leeway to try to get his affairs in order once he's released. If you'd give him maybe just 2 hours a day or something, or a couple hours for the whole week, in case he needs to buy things or get his life situated. But he would stay home 99% of the time. He's just asking if we would give him a little bit of leeway to fix whatever mess his life is in now that he's been in custody for 20 days.
Well, this court gave your client leeway, and look how that
I
turned
understand.
out.
I understand,
So I
Judge.
don't, and the representation that your client hasn't received any medical treatment, so I'm presuming he hasn't received any mental health treatment either. So I have some concerns regarding all of that. And so if your client has somewhere he has some affairs he has to take care of or whatnot, then most of those can be done remotely.
That's
He can have,
that's fine,
he
Judge.
can have things delivered to his home. So what I will do is I will allow him a total of 3 hours per week. That's it.
Understood.
How he sets that up, and he would have to notify a tether unit as to what it is that is. I'm going to order 3 hours per week, and that's it.
Fair enough, Your Honor. He's going to comply with your orders.
So previously, this court had issued a $10,000 personal bond and those bond conditions. Is your client able to post a $10,000 10% bond?
Judge, at this point, I don't think he is, given that he's been in custody and he doesn't have access to any funds right now. He retained Miss Michaels and myself before going into custody. I don't know what his financial situation is right now. I don't think he has any money to be able to post at this point.
He has no access to funds. We're asking for a personal bond.
This court's going to order a $20,000 personal bond. You are not to be released on alcohol and GPS tether through the Wayne County Jail. Sir, one violation, any detection of alcohol, Wayne County Jail will be out there to pick you up, sir, and arrest you, and you'll be right back in the Wayne County Jail.
Understood, Your Honor. I have no intention of reoffending in any capacity whatsoever.
Okay, so I'm also making the note on here, defendant to be screened for regional wellness and recovery court. That's what we, our treatment court.
All right. Thank you, Your Honor. Thank you for your patience with us.
Thank you. Have a good day.
You too, bye.
Thank you very much. You too. Bye-bye.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience left. And trust me, out of the day, I'm sitting up here, I'm the one that needs you, Greg.